They travel by the thousands from South Texas and other parts of the country every year, heading north for work. Their jobs are hard, their pay is low. Migrant workers like Maria Ayala say there's also verbal abuse.
They even called us wetbacks. They did.
Ayala and these other workers from Mission went to work for a company called Pioneer Hybrid International in Indiana about 2 years ago.
It wasn't right.
This is the type of work Ayala and the others did. It's called corn detasseling, part of the harvesting process. These workers claim their bosses forced them to work in fields while those fields were being sprayed with pesticides.
2 days later, we started getting some rashes on the body, and we even told them, but they didn't even pay attention until one of them got real bad.
Under federal law, agricultural migrant farm workers don't get some protections that people in other industries do. No overtime pay is provided. Ayala and the others say they were told they would be paid about $75 for each acre they detasseled. Most workers finished about 2 acres a day. Instead of being paid by the acre, they say they were paid minimum wage. After the first week, they only received $113.
After all those hard working days we had, like waking up early, getting all wet, like feeling all sticky and everything, for $113, it's not fair.
The workers say they were promised a total of $3,000 to $4,000 for 3 weeks of labor. Instead, they received about $400 each.
He make us feel like we were very low, very low.
We checked federal court records and found that Pioneer International has been sued by South Texas workers at least 15 times, dating back to 1979. In some cases, the company and the workers reached settlement agreements with confidential terms. We found this case filed in federal court in McAllen. Several workers claimed they were not properly paid for work they did in Iowa in 2007. Last year, a judge ordered the company and a recruiter to pay a total of $13,800. That was divided among several workers. Some were paid a little more than $2,000. Some minors, underage workers, received about $400. Attorney Edward Sandoval says the laws are stacked against workers like Ayala and the others. Plaintiffs cannot recover punitive damages. They are meant to punish defendants for wrongdoing. Workers can only recover the amount of money they would have been paid in the first place, called liquidated damages. Sandoval also says the fines for breaking the law are small.
As in for the Agricultural Act, it was passed in the early 80s, and the statutory damages are frozen, as in what they were back in the 80s, $0 to $500 per violation. There's been no stepping up because of inflation or passage of time.
Pioneer has a plant here in Weslaco. As you can see, the sign says no photos or video are allowed inside by employees or visitors. The company's headquartered in Des Moines, Iowa. No one would talk on camera, but they did release a statement. Because litigation is currently pending between TRLA and Pioneer, we believe the litigation is the correct forum to provide specific comment with respect to the allegations raised by TRLA. Pioneer denies the allegations and believes they are unfounded. We do have a long-standing, successful history of employing agricultural workers to work for Pioneer in Indiana and other states. Pioneer is not the only defendant in these types of lawsuits. In April, an Indiana company, Remington Seeds, reached a settlement with 91 people for work they did from 2006 to 2008. The company paid out more than $220,000 to settle the case. Remington's website says they treat their employees as family. The attorney for the 91 workers who sued says that was not true for her clients.
A lot of the workers went up there and got paid hardly anything and were stranded sleeping on the side of the road without even the money to come home. Some years they were also promised food on the trip, and while they were up there and they weren't, and they would go ask for food, they would ask the contractor for the food they'd been promised, and he would say, yeah, later, and so they were just going hungry without any transportation in these rural motels, without any way to even go to a grocery store and without any money to get food.
The settlement averages out to about $1,500 per worker after attorney's fees. While Remington does not have a plant in Texas, a judge ruled that workers can sue them in Texas federal courts because the company maintained continuous and systematic contact with the state. Remington released the following statement through their attorney. Remington Seeds utilizes independent contractors who employ in excess of 1,500 migrant workers each year who work in fields where Remington's corn is being grown, and 99% of them have had no complaints and enjoy the experience. Most of the contractor's workers come year after year to work in fields where Remington's corn is being grown. A judge also ordered recruiter Abel Mendoza to pay the workers $337,000 in the Remington case. Welch says they are trying now to locate him to collect.
That you're mentioning and how you guys were trying to track these